rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. All right. Good morning. We are here for oral argument in our case number CV24-0484, Stith v. Vita Health et al. So reminder to everyone in the courtroom, please silence your phones to avoid any disruption or embarrassment. Now, as you know, we record and live stream these proceedings on YouTube, so we would appreciate if you give your name and the name of the folks that you represent when you begin speaking for that record. Each side has a maximum of 20 minutes. You are not required to use all that time, but it is yours to use at your discretion. The clocks on the podium, of course, reflect your remaining time, and if appellant would like to reserve, that's your obligation to track that. Do keep in mind we've reviewed the briefing. We are familiar with the record. We have already discussed the case this morning, and with keeping that in mind, please feel free to proceed.
Good morning. May it please the court and counsel. My name is Mike Ryan, and I represent Vita Health and Rehabilitation. The appeal before the court is simple and straightforward. Respectfully, the trial court erred in denying defendant's motion for judgment as a matter of law at the end of plaintiff's case in chief. We seek that this court reverse that ruling and enter judgment in favor of Vita. As this court knows, this is a medical malpractice case. It involves allegations of failure to monitor. There was a head bump during a transfer from a wheelchair to the bed, and it is the conduct after the head bump that plaintiffs criticized in their case in chief. The standard of care criticisms of the plaintiff's case were threefold. First was failure to perform neurochecks, which entails, without going into specifics, monitoring the patient. Second was failure to report to a physician the head bump. And third was the failure to hold narcotic pain medication. In plaintiff's case in chief, plaintiffs did not introduce medical expert testimony to a reasonable probability that any of those three standard of care criticisms were the proximate cause of the injury that plaintiff claims, which is a brain bleed that resulted in cortical blindness. That was not done anywhere in the case in chief. The court has seen the record. We went through the evidence on pages 7 through 9 of our brief.
Counsel?
Yes.
What's your best argument for our ability to even review a 50A motion independently from the denial of the 50B?
Absolutely, Your Honor. What the best argument is what the law says, and the law says that if we make a motion for judgment as a matter of law, Rule 50A motion, and then renew the 50B motion, then it's reviewable. And that has happened on many different occasions. And so...
But where is one where, point me to a case where we review the 50A motion but not the 50B?
Okay.
I mean,
I don't...
I found a lot of cases where they make a 50A and then make a 50B, and then you review it and the court reviews the 50B. So I guess actually what I'm asking is, what's your best case for the proposition that you review the 50A independent of the 50B, frozen in time as the state of the evidence at the 50A motion?
Okay, excellent.
In my case, that's what this all turns on. This, in my opinion, I'm not speaking for the panel, but it's what is our standard of, or what is the evidence we review, and that depends on whether we review the 50A motion alone at the time the 50A motion was denied.
The Orm School case talks about...
Orm's a summary judgment case.
It is, but it talks about the JMOL standard, and that's the Rule 50A. Orm School says that summary judgment and Rule 50A motions are identical. In and they're to be considered identical. And the court then said that it is at the time of the submission of the materials for summary judgment, which would apply to Rule 50A, that the court would decide the issue as a matter of law. In addition, Judge Morse, it's important to remember a review of Rule 50A is de novo. And so and there are tons of cases that say that. So if a review of a 50A motion is de novo, then how can it not be frozen in
There are
time?
tons of cases that say specifically review of a 50A motion on appeal, because I couldn't find any that discuss a review of Rule 50A motion.
That say that Rule 50A motions are reviewed de novo by this court. That's what I'm saying.
Give me one of those.
Okay.
Because I didn't see any cited, they argue, they spend a lot of their time in their brief disputing whether we can even review a 50A motion. I didn't see a specific case in your response that says, oh yes, here's an example of a Rule 50A motion being reviewed on appeal de novo.
Earl versus State, it's a decision by this court, which is not a binding decision. It's a memorandum decision.
What's the site for that?
216 Westlaw 7104893.
216 Westlaw?
Yeah, 216 Westlaw 7104893, and we did cite
2016.
2016. I'm sorry. Yes, 2016, and we did cite that in our materials.
Okay.
So,
But maybe that's what I was meaning when I spoke earlier. Published cases that say a Rule 50A motion is reviewable. Can you point me to any of those?
well, I think that Orm School and also this court's decision in Monty, which is also a memorandum decision, but Orm School certainly says that a Rule 50A is reviewable because it talks about the similarity between summary judgment and Rule 58 motions.
Okay, so yes, Orm School and other cases apply that JMOLs are reviewable, but we have this weird jurisdictional issue. I'm not sure exactly what it is. It says a Rule 50A motion is not reviewable unless there's a Rule 50B motion made. And
Right.
Now, and I think it's Williams v. King who talks about that. Yes. Why then? What's the purpose, or what's the reason? How do I interpret the rule to give effect to both of those principles? Because if you have to renew that in a Rule 50B motion, why would we only review the evidence that was introduced at the time of the Rule 50A?
Because the court made a mistake as a matter of law in denying the Rule 50A.
Okay.
That's why.
But then why do you have to re-urge the Rule 50B at the end?
I can't explain that. That's just a weird procedural thing. But it doesn't make the Rule 50A motion not reviewable. If a court makes a mistake as a matter of law, and the standard for reviewing a Rule 50A is de novo, then of course this court has the ability, and indeed the responsibility, to review a Rule 50A decision that's wrong. A trial court can't just make a mistake as a matter of law and then that be ignored, and us not be able to come to this court. Sorry, Your Honor.
You're okay. Let me start at the end. On appeal, your client is not challenging the jury verdict, correct? That's not an issue that's being challenged on appeal.
We are not challenging.
The basis to reach the verdict it did, correct?
Yeah, we're not challenging the jury verdict. What we're challenging is that everything after the judgment as a matter of law shouldn't have ever come in.
Right. So let me go backwards. So your client's also not challenging the 50B ruling, that the denial that the trial court entered denying the 50B motion, correct?
No, we are challenging.
On appeal you are?
Yes, we are.
The 50B?
The 50B, because we believe that it was improper for the court to exercise her jurisdiction, or to exercise her discretion in allowing Dr. Woodcock to testify about any of the stuff that he did on quote-unquote rebuttal.
The 50B only as it relates to 50A, though.
Absolutely. It all is interconnected, and that's why I'm having a little bit of a hard time saying, well, how do you separate them out? Because you don't. But if the court makes a mistake of law, which the trial court did here, I mean, it's clear under Arizona law that she erred. There was no...
So I need you to educate me on something then.
Sure.
Walk me through. So if, let's say we agree with you. Let's say I agree with you that the court erred in denying the 50A. Could plaintiff have then moved the court to allow it to reopen its case in chief?
Absolutely. They had that right.
Okay. Would the court have either erred or abused its discretion if it denied that motion?
Absolutely not. It would be appropriate for the court to have denied that.
But it would have been a discretionary call. We probably would have to affirm either way, right?
That would be true, except the mistake that is interconnected, and that is the mistake of law.
Why did you guys even put on I'm sorry, let Judge Williams.
Sure. So let's say Judge Julian had granted the 50A motion, and plaintiff then said, Your Honor, we moved to reopen our case in chief. Court says granted. Dr. Woodcock then testifies to exactly what he testified on rebuttal. Is there an error at that point if a 50A is renewed and the court denies it? Would there have been an error then?
Yes,
Why?
because Dr. Woodcock's testimony was not rebuttal testimony. It simply was not rebuttal testimony.
No, but if it had been reopened,
I see.
His injury causation testimony would have been part of the case in chief, correct? And as I understand it, and you correct me if I'm wrong, your client does not challenge that injury causation testimony was given on rebuttal. It says it shouldn't have been allowed to give injury causation testimony, but it's not challenging that the injury causation testimony was given. Is that fair?
Whether it was sufficient, we are. And if you look at our brief, and I think this is really very important. If you look at our opening brief, and you go to page 7, this is what the plaintiff's attorney said Dr. Woodcock's testimony was going to be about. And this was to the trial court, and it's on the record. We have asked Dr. Woodcock to, in terms of the causation, to deal with the effects of what the subdural hematoma does after it has begun to grow. He is not going to talk about what caused the subdural hematoma. He is going to be talking about what the subdural hematoma caused in terms of medical behavior, neurology causation, end quote. He wasn't going to be talking about the neurochecks or the failure to report to the doctor or the failure to withhold pain medication and the cause of those things. So how can he be allowed at the last second to come in and give quote unquote new testimony? He can't. That wasn't his role. It was never his role. And that's from the mouths of the plaintiff's attorneys themselves. So then it goes to, and since we're on this topic, I know, Judge Morris, you had a question, but since we're on this topic, with respect to even his testimony on rebuttal, that was all conclusory opinions not supported by facts. He didn't go into the intervals of when the neurochecks were being performed and how that would have proximally linked the causation aspect to this patient getting into surgery in time. The court has to remember, after she was found completely unresponsive, it took 10 hours to get her into surgery. That's after she's found unresponsive. Plaintiff's expert, the causation expert, the neuroradiologist, testified that it was 6 hours from head bump that was required to get this patient into surgery to avoid the cortical blindness. He didn't causally link that either. And this court knows that just saying conclusory words is insufficient. That's the Flores versus Sargent case. You can't just have an expert say, oh yeah, it's causally linked, like Dr. Woodcock did in his rebuttal testimony. And so there simply is not, even on the 50B standard, they have not met the burden that is under the Sampson case and this court's decision in Barrett versus Harris. You have to causally link specifically each and every standard of care criticism to the injury. Where is that in the record? It's nowhere. And that's why the trial court's error was so pronounced, because when we made that motion, what was the state of the record? And in the Monty case, the 2024 case, this court said, we only consider what the state of the record is for summary judgment. Only what is before the court. We don't consider stuff after. And so the state of the record was nil.
So counsel, help me, I appreciate you pointing that out. I'm trying to understand as a practical matter.
Right.
If the court had granted the 50A because no injury causation testimony had been offered, and your position is the court would have had discretion to allow plaintiff to move to reopen the case in chief and put on what was the rebuttal testimony, to put that on in its case in chief. I'm trying to understand what's the difference. I get procedurally you're saying you can't introduce new evidence on rebuttal. I get that. But as a practical matter, once the court denied the motion for judgment as a matter of law, what's the difference between then the causation testimony coming in rebuttal versus coming in case in chief and a reopened case in chief?
And I think the bigger question he's getting to is, doesn't the court's error then hurt the plaintiff here? I mean, because if they granted your 50A, they could have reopened their case and presented the evidence. But if by denying it, your argument is they're just SOL.
Well, two things. First and most importantly, they didn't ask to reopen their case.
But why would they? Because the judgment as a matter of law was denied. So why would they ask to open it?
Because to protect the record. You protect the record. You have to reopen it. I mean, we're having this discussion, and the discussion itself begs the question, why don't you protect the record? Why don't you say, I move to reopen the case? To the degree, even an argument of the 50A, why don't you say, well, Your Honor, we don't think you should grant it, but in the alternative, if you do, then we want to reopen our case.
Or if you're inclined to grant it, we'd ask you to reopen, because here's what we testified to.
Exactly, and that's the responsibility of the plaintiff's side.
Let me turn that back on you. Why didn't you guys just at the end then rest and not give them an opportunity to put on this evidence in rebuttal?
Because that is extremely risky. And frankly, again, we didn't think it was rebuttal, and we still don't. We don't think it's rebuttal, Your Honor. And I just read to you what the plaintiff's lawyer said Dr. Woodcock's testimony was going to be. Where in that does it say he's going to causally link the 3 standard of care criticisms? So why would I then not put on my case? Our case was important. And our doctors testified that there was already a pre-existing brain bleed that took up significant space, so that when this little minor head bump caused it to reignite, there wasn't very much space to begin with.
You've only got 1:45 if you want to save it for rebuttal.
I think I will. Thank you.
it please the court? I'm Brian Sutherland. I'm here on behalf of plaintiff and appellee Peggy Stith. The evidence presented at the trial supports the judgment, and what Bella Vita asked this court to do is to disregard Dr. Woodcock's rebuttal testimony. But Bella Vita has no legal basis for that request. A reviewing court may not ignore part of the evidence in ascertaining whether the evidence was sufficient to support the jury's verdict and the judgment. The jury here
But the
heard...
question is not, the really critical question from the discussion here is not so much the jury verdict evidence, but it's the JMOL at close of your case.
Yes, Your Honor. So the order denying the Rule 50A motion is totally unreviewable, just as an order denying a motion...
Assume just for the moment, and this is hypothetical, assume for the moment that it is reviewable. Why was it error? Or why was it not error to deny the motion?
Well,
Did you dispute that you failed to put on direct causation as evidence as required by Sampson?
we certainly do dispute that, Your Honor, but let me try a different tack before we get to the evidence, which is to say the text of Rule 50A grants discretion to the trial court to grant or not grant the motion. Rule 50A says the trial court may grant the motion. That's not a command. And what Marquette says, what Unitherm says, and what the Wright and Miller Treatise all say is that a trial court has discretion to grant or deny the motion. And given that discretion, it cannot be an error for a judge to deny a Rule 50A motion. And that stands in contrast, I would add, with the language of Rule 56. Rule 56 says that the trial court shall grant a motion for summary judgment. Rule 50A does not. It says may, and that's for a reason. We're talking about a motion for judgment of matter of law made under accelerated circumstances midway through a trial. And it's not reasonable to expect a trial court to be able to make a decision with that amount of weight, with that amount of consequence riding on it very quickly. When a judge decides a motion for summary judgment, they take weeks, they take months, there's a lot of briefing. Judgment for matter of law midway through trial is completely different, highly accelerated. Judge has to make a very quick decision because the jury is waiting. That's one reason why the rule says may. And what all of the cases and the treatises say is the better practice is to allow it to go to a jury. So it cannot be error to deny it. Even the court had the power to do so. Marquette says exactly that. And to answer one of the court's questions, the reason...
That line of reasoning suggests, I mean, we're in a narrow space here, which is the medical malpractice space. The rule, of course, applies broadly to civil cases. But in this space, we have cases, in fact, Sampson, which is a 2021 case, which gave very explicit direction as to the type of expert testimony that is required in your case in chief. So it is midway through trial, but it is at the end of your case in chief. The plaintiff has said, I'm done, I rest, I am telling the court that I have put on what I have available to meet my legal obligations. And the court at that point has direction from our good friends upstairs saying, and these are some boxes that must be checked. One of those boxes is not checked. How is that really a discretionary ruling?
Sampson doesn't say anything about a case in chief because Sampson is a summary judgment decision. And what Sampson says is that a jury can't get a case unless there's enough evidence to support the jury's decision. If you're at a summary judgment stage, then the court has that obligation under Rule 56 that I mentioned, where you see the word shall. So in Sampson, the trial court granted summary judgment. This court reversed, and then the Arizona Supreme Court reversed this court.
You had rested. They made their 50A motion. Assume then that, like I asked your colleague, that they hadn't put on a defense case and then just immediately renewed their Rule 50B motion. Sampson would require, under the hypothetical she proposed, that the court then grant the motion, right?
Sampson would not require that, Your Honor, because again, Sampson is a summary judgment case, but we're talking about a mid-trial Rule 50A motion. As the court was discussing earlier with my colleague, under Rule 50A, the court has discretion to reopen, and here the trial court said, if that motion had been made, I would have granted it. In fact, the trial court said, I had an obligation to allow reopening if that motion was made.
Move for reopen, so I don't really know why that matters. So I'm saying, answer the hypothetical, please, which is, there isn't, your rebuttal testimony came in and she had posited, and I know you guys dispute that there wasn't sufficient evidence at the time of the 50A to survive Sampson's standard. wouldn't it have been an error for the court to deny the Rule 50B motion at that point?
If there's a Rule 50B motion,
Yes.
and the evidence is
Your rebuttal evidence had not come in, and your initial case in chief evidence didn't meet the standard.
Okay.
Are you arguing that you wouldn't have to grant the JMOL at that
Okay,
point?
let me see if I understand the hypothetical. We're just,
Yeah, it's getting complicated.
we assume for the purposes of the question that the evidence is insufficient. Of course, we dispute that. If the evidence is insufficient and a court erroneously denies a Rule 50B motion after a jury verdict and after a judgment, then the court reviews the erroneous denial of the Rule 50B motion.
Okay.
But I think his question was, isn't the court obligated to grant the 50B motion if at that point there had not been sufficient evidence?
Rule 50B, sure. Yes, after a jury verdict, you're looking at all the evidence. And one of the questions was, why do we have this Rule 50B motion? And the reason why we have it is because the judge's obligation...
Rule 50B, though, says the same may language. And you just told me a minute ago, Rule 50A means it's never error to deny a 50A motion, but Rule 50B says may too, so it would never be error to deny a 50B motion.
I'm not sure if I follow that, Your Honor. I mean, on Rule 50B, we're talking about all the evidence is in. There's a motion for judgment as a matter of law.
Yeah. And it says in ruling on the renewed motion, the court may allow a judgment, order a new trial, or direct injury judgment as a matter of law. So
Yeah.
it may mean something different in Rule 50B than it means in Rule 50A.
Well, perhaps the judge has more discretion at the Rule 50B stage than I realized, because I really did focus, as Your Honor did, on the question whether the judge is required to make a decision under Rule 50A. And what Marquette says is that it's undisputed that when considering a Rule 50A motion, a trial judge is not required to grant judgment a matter of law, even in a case in which it has the power to do so. I mean, that's this court's decision in Marquette, and it follows what the U.S. Supreme Court said in Unitherm. Both of those are cases that say the judge has the power to allow the case to go to the jury. And the reason for that is because if the evidence is indeed weak, perhaps then the jury will render a verdict for the defense if there is no more evidence. But in this case, there was more evidence, as this court is fully aware. On rebuttal, Dr. Woodcock testified, and he was fully entitled to do that. The judge had discretion to allow that. And I think as a matter of practical reality, and if we're talking about the practical reality of what would happen here, I mean, my colleague is saying the appellate court's obligation on an appeal after a jury verdict and after a judgment is to review two cases. He wants review of the evidence as it existed at the time of the Rule 50A motion. He also wants review of the evidence as it existed at the time of the Rule 50B motion. If you accept that rule, which would be contrary to Marquette and Unitherm, you would be creating conditions under which there would be an appeal in every case after jury verdict, and you would be asked to review two records, one at the 50A stage and one at the 50B stage. And there's no good reason for that, for the same reasons this court has explained.
I'm sorry, review two records. It's just whatever came in afterwards. I mean,
But you're making...
It's all one big record, and it's just when do we stop looking at it, right?
Well, right, but you would be making a different legal determination based on one set of evidence, right? I mean, the evidence was different at the Rule 50A stage, right? That's the whole point of this case. It's different at the Rule 50A stage than it is at the Rule 50B stage. So you'd be making a sort of artificial determination at Rule 50A.
We have a principle in Arizona that, and by the way, I was on Sampson at the appellate court where I thought, I still think the Supreme Court got it wrong. I think there's some inferences, but I was smacked down pretty strongly on this. So you can't allow inferences. The jury, there's got to be direct causation evidence. So I am hung up on this case on the issue for me is whether we measure it at Rule 50A or not. And I'm tipping my hand here. I don't speak for the panel at this point, but I don't see you have the direct causation evidence that Sampson requires at the time of the Rule 50A. And we have another principle in Arizona that when there isn't clear case law on point, we can look at the federal sources for our cases, and because under interpreting the rules. And there are a couple federal cases that say, without much explanation, that you measure a Rule 50A motion at the time at the time it's made. Tennick v. Omni Shoreham Hotel, 265 F. 3rd, 1139 out of the DC Circuit, and Marinelli versus City of Erie, Pennsylvania, 216 F. 3rd, 354 out of the 3rd Circuit. Both of them say that, you can't use post-JMOL testimony to defeat a JMOL, which there's some intuitive appeal to that. How do I find that the trial court erred based upon, or not erred based upon something that happened after the ruling? So help me get around those cases.
I believe I can help you, Your Honor, because I think what the court needs to do is focus on the distinction between an order denying a Rule 50A motion and an order granting a Rule 50A motion. Of course, when a court grants a Rule 50A motion, then the judgment entered upon the order granting a Rule 50A motion is then reviewable because you have a final judgment and the evidentiary presentation has ended. The cases that they cite are all cases in which the Rule 50A motion was granted. In some of their cases, I think there's one of them, there was additional evidence that somebody offered after the Rule 50A motion was granted, and the court said, no, we consider the evidence that existed at the time of the Rule 50A motion. Well, of course that's true when the Rule 50A motion is granted, but when it's denied...
I think Marinelli actually is the opposite situation, the Third Circuit case. So it was the plaintiffs in that case were arguing, no, we addressed this later, and the court said, no, you can't use post-JMOL testimony to address it. So, but I could be mistaken. I don't have the case right in front of me.
Yeah, I don't have that case in front of me either, Your Honor, or remember it. But I think the same logic applies. I mean, one thing that's said is that the review of a motion for some...
And I should warn you, I don't think these were cases they cited. I think it was cases that I perused around on Westlaw with my clerks and found.
That would make it even more difficult for me to respond, Your Honor. So if the court intends to rely on that case, I would offer supplemental briefing if it's at all relevant.
If you guys think you want to file something, you can. But.
Yeah. I don't think it is because Arizona law says, that the order denying a motion for summary judgment is unreviewable, and that's because to hold otherwise would lead to the absurd result that one who has sustained his position after a full trial and a more complete presentation of the evidence might nevertheless be reversed on appeal because he failed to prove his case fully at the time of the hearing on the motion for summary judgment. And I'm quoting there from Navajo Freight Lines. And doesn't the same logic of Navajo Freight Lines apply with even greater force to a mid-trial Rule 50A motion? Meaning, if there is evidence presented after the Rule 50A motion, what sense would it make?
But then I get what's the point on a 50B then? How is that different than a 50B?
If you're asking why the 50A and the 50B are different?
No, if you're saying that a motion, we should equate this to a motion for summary judgment because a mid-trial Rule 50A, after you've rested, can never be reviewed because we can't review denials of summary judgment.
Right.
Why can we review a denial of a 50B?
Because there's no evidence after the 50B.
But you've been fully heard at the time you've rested, so what?
Not if the trial continues. I mean, I'm just not following. The Rule 50B is after as the court knows, is after the judgments. There's no more evidence. I mean, the basic principle that the cases state, one that I think makes tremendous sense, is that this court's review should be based on the full presentation of evidence, not on the presentation of some earlier point in time. In other words, why would a court ignore evidence that the jury actually heard? In other words, even if the trial court erred, and we certainly don't concede that, but even if there is an error in denying a motion for summary judgment, even if there is an error in denying a mid-trial Rule 50A motion, that error is of no moment because additional evidence in the case fully sustains the plaintiff's burden, and the jury rendered its verdict based on all the evidence, not just based on what had been said at the time of the Rule 50A motion. And so from the jury trial point of view, the Rule 50A motion, that's not something the jury even knew about. There's no basis in the text, the purpose, or in the public policy rationale for the rule to say we're going to cut off the case based on a Rule 50A motion, even though we wouldn't do that on a Rule 56 motion for summary judgment, Your Honor.
Counsel, will you educate me a little bit, walk me through this on a 50A motion, if it's granted, or the trial court says, I'm inclined to grant it, what's the legal authority that says a plaintiff can then move the court to reopen? What's a good case or rule you can point me to?
Sure. Marquette says exactly that.
Okay.
Marquette says Rule 50A is based upon the premise that the claimed omission in proof might be cured by reopening of plaintiff's case if the trial court finds merit to the motion.
Would it be error, either abuse of discretion, legal error, for a court to deny a motion to reopen?
If you had that set of circumstances, then you would review the denial of the motion to reopen for abuse of discretion, I suppose. So I guess we're hypothesizing a situation in which a court grants a Rule 50A motion, quite different from our case, then denies a motion to reopen. In that circumstance, I believe you would review the denial of the motion to reopen for abuse of discretion.
So it would be fact dependent.
It would be fact dependent, yes. That's not our case, but you would, and in this case, as I pointed out earlier, the trial court said if it had been made, it wasn't made because she denied the Rule 50A motion, but if it had been made, I would have granted it. So you would find yourself right back in the same situation that Your Honor was discussing earlier with my colleague, where if the motion had been granted, the Rule 50A motion, and then there was a motion to reopen because the court in that hypothetical circumstance would have identified some gap, we would have moved to reopen, and then the very same evidence would have appeared in the case in chief. You'd be in exactly the same position. And that's why the arguments that my colleague is raising are arguments that don't make any material difference.
One follow-up question. I may have written this down wrong, but I thought early in your argument, talking about the language of Rule 50A, you'd said courts have said, or it's well settled, that it's a better practice for a court to let a case go on, to deny a 50A, that it's the better practice.
Yes, sir.
Are there cases that say that it's the better practice to do that?
Yes, Your Honor. I was quoting from the U.S. Supreme Court's decision in Unitherm. It says, the quote, appellate courts repeatedly have said that it is usually desirable to take a verdict, and then pass on the sufficiency of the evidence post-verdict motion. And I think that decision in U.S., the Unitherm is the one you should follow here. Marquette already followed it. You have the Rule 50B motion.
That's the practice, though, of saying, I'm going to hold off until the jury decides and then decide it. It's not that you can't upset the jury verdict if the trial court disagreed with it. It's just they're saying you should let the jury reach its verdict and then decide your Rule 50B.
Well, right. I did quote from Marquette earlier. It says the court has discretion
it's well established in Arizona and elsewhere. We want juries deciding these cases when the parties have presented sufficient evidence to get it to the jury. And isn't that all those cases are saying?
I think so, Your Honor.
Okay.
I appreciate that. I'm just checking my notes.
If you can respond briefly to, since you got a little time, his arguments or your colleague's arguments about the appropriateness of the rebuttal testimony, because maybe we can bypass some of these. Well, he would argue we could bypass some of these big issues that are difficult if that rebuttal testimony shouldn't have come in at all.
No, one of the things they said in their reply brief that was troubling to me was that Dr. Barakos had not testified about the efficacy of neurochecks, but if you look at the record, he very clearly did. He was asked the question, would the neurochecks have made any difference here? He said no. So he answered the question he was asked, and then over...
That opened the door to your rebuttal.
It indeed. And this was not like a snap decision that the trial judge made. The question whether Dr. Woodcock would give rebuttal testimony was disputed over a span of 2 days. It was argued. The judge thought about it very carefully, and then she made her decision. This is very far from an abuse of discretion, both because it was directly responsive and because the parties were very fully heard on the question whether Dr. Woodcock should testify at all. And the testimony he gave was completely responsive to what Dr. Barakos had said, and it fully carried the plaintiff's burden of proof with respect to the element of causation. He testified that the neurochecks, to a degree of medical probability, would have enabled a physician to be called, which would have resulted in medical intervention at an earlier point in time. And he did make distinctions. I think my colleague said that he didn't make any distinctions between the period of time that would have been called, but he did. He talked about if the neurocheck would have uncovered, distress or symptoms at, the first neurocheck or then the second neurocheck, that would have created the earlier intervention. He talked about the difference between whether if you have an intervention before herniation or after herniation. He talked about that in his rebuttal testimony. And we had a lot of testimony in this case about how time is brain and how the injury is ongoing, right, both before and after the herniation. There is nothing to suggest in this case that all of the injury happened all at once and then stopped. That doesn't make any sense. We know that when a stroke is occurring, the brain is pushing down on the blood vessels.
Thank you, counsel. Your time has expired. We appreciate your arguments.
Thank you for hearing from me. I really appreciate it.
Resting your case has to mean something. As Judge Perkins noted, you have to introduce the prima facie elements of your case. That's black letter law. That's for summary judgment. That's for judgment as a matter of law. If you don't do it, you haven't made your case.
Counsel, Rule 58 talks about being fully heard, a motion being made after the plaintiff's been fully heard. Does that mean once they rest their case in chief? So is that a yes?
Yes, it is.
And so if rebuttal, regardless of what the rebuttal testimony is, if rebuttal is later offered, does being fully heard include the rebuttal?
No, it does not. And that's the Tobin case. That's why that Michigan case is important. It talks about that. The allegation there was that they should have monitored, and again, it's a failure to monitor case. They should have monitored the temperature both before, during, and after the operation. And there was no expert testimony tying that together. And as a result of that, what did the court do? The court said you didn't make a prima facie case. All of the stuff that came in after and the ability for rebuttal testimony to come in, all was error. Because you look at things from the time that the error of law was made. It doesn't make any sense to have a standard of review of de novo for a Rule 50A motion and say the court has discretion if the plaintiff doesn't meet their prima facie elements. That's a responsibility that cannot be deferred.
Thank you, counsel.
Thank you.
We appreciate both of your arguments and your time preparing for them.
Thank you very much.
We'll take the matter under advisement and issue our decision in due course. With that, court is adjourned.